Estate planning, is it good enough anymore? Or do we need to adopt a more holistic approach? Do we need to adopt a strategy that aligns with the idea of holistic estate planning being the new normal, being the new thing that we all absolutely have to embrace? Let's start with one of those said case studies and have in the back of our mind the difference between a traditional estate plan, so an estate plan where we really just focus on the will, estate planning just being a fancy way of saying will, as opposed to holistic estate planning, which is focused on touching, thinking, considering, factoring in a raft of different issues, not least of which how we achieve the balancing of the ledger. So how do we achieve equalisation? And to call it out really early in terms of today's program, we've said that additional word into the slides from the get-go. So if you actually look at the way in which the program itself has been marketed, it talks about balancing adjustments in wills. Let's call that out from the get-go, because I think it is perfect in terms of positioning today's program. It is the right heading. It is the right approach for what most of us in this space gravitate towards too. However, it also very neatly, very directly, very starkly draws out one of the key principles that we want you to take away today, and that is, if we are only considering the will itself, there is a material risk that in the vast majority of situations, trouble will be there not too far away. What's the case study we're going to go through? Well, we're only going to add in one additional part of the factual matrix to someone having wealth in their personal name, so the will maker dealing with wealth in their personal name. We're going to whack in a family trust. That's the only asset involved. They had done an estate plan some years earlier. It was a blended family situation. Mum was giving her personal wealth to her second spouse. She was giving the assets inside the family trust to the children from the first relationship, adult children from the first relationship. It was about equal. So she'd balanced the ledger. She didn't need to worry about any additional equalisation clause under the will. And that was a bit of a set and forget strategy. All she really thought about over time was making sure that the assets in the family trust were about equal to the asset of the family home. She didn't really spend a lot more time thinking about that. She felt that the 50-50 split was about right. And at the time she did the will, there was about $4 million worth of wealth. By the time she died, it was about $6 million wealth. You've heard me say it before, there's a reason I had to become a lawyer, even though I've got an accounting degree. My math is not very good. You'll notice that all of the dollar amounts that we talk about today, keep it very, very simple. $6 million estate, $3 million inside the family trust, $3 million in the family home, 50-50 split, all happy days. Until not too long before the date of death, an ARR was done. And for those of you following along at home, try not to use too many TLAs today, but TLA number one is an ARR. Well, in fact, it's probably number two. Number one, TLA itself being a three-letter acronym. Number two, ARR, an asset revaluation reserve. Why is that relevant? Well, it's a strategy that a lot of accountants will use in a lot of instances to try to shift value around a group. In this instance, that was done, a tax-free decision to do that, distributed out to the will maker. She then lent it back in. The estate plan was not revisited. How are we going then with our trying to get a balancing of the ledger under the estate plan? Mum goes and dies. What is the nature of that loan back under mum's estate? Well, it's a debt owed to the estate, repayable on demand. It's an ACCOR loan. Overlay my very elementary comments as we went through there in terms of the values and the fact that dad, number two, so her second spouse, was the sole beneficiary under the estate. What did he end up with under that estate plan? Well, he ended up with, call it, about $6 million. And what did the kids end up with under the estate plan? Well, call it about zero. So one decision, we're not blaming anyone here. This is a collaborative approach, whether it works well or works badly. But one decision by the accountant at one particular moment in time has seen a complete and utter rebalancing of the intentions and the second spouse walking away effectively with the entirety of the estate. Now, the kids still got, and in fairness to the advisors involved, the kids still got full control of the family trust. The issue was that asterisk down there, because of the at-call loan on the balance sheet, the control of the trust only really gave them the right to sell all the assets of the trust in order that they could repay the loan that was owing to the estate. Now, for those of you that are looking at that and going, oh, Matthew, does that really happen? Or you might be sitting there saying, well, hang on, Matthew, that sounds exactly like some other cases that I've actually seen go through the courts in the last few years. You're right on both counts. So absolutely, we see that happen. We've got, I think, 3 situations at the moment, not necessarily an ARR involved, but certainly a failure to consider the loan accounts, the credit loan accounts with the family trust, and reoccurring ongoing issue that is happening across the board in our experience. The second thing that we would add is that, yes, if you're thinking about cases like Clark and Inglis, if you're thinking about the Fisher decision, if you're thinking about some other decisions that we can touch on as we go through, depending on the questions that come through the discussion panel, as Lisa said, you would be entirely right. So the factual matrices on each of those high-profile decisions are a little bit different. They're touched on in your material. We can give you more context if that is going to be relevant to you. The key principle that we're wanting you to take out of those initial examples, however, is that this does happen. When it does happen, it can quite often cause an absolutely radical, fundamental readjustment of what was otherwise intended under the estate plan. And frankly, an equalisation clause under a will in that style of factual matrix probably of itself is not going to be enough anyway, particularly where you're looking in that example with a blended family, where you've deliberately carved out personal wealth from controlled wealth and tried to create that demarcation. What does that mean for us in terms of where we're going to go for the balance of today's program? Well, a lot of the case study examples that we go through will look at this interplay between what I call the law or the black letter law and that other outstanding Australian legal principle from that Australian documentary, at least for the lawyers online, you'll know it as a documentary, The Castle, and that legal principle being it's the Constitution, it's Mabo, it's the vibe. And we'll see that concept play through not only in some of the case studies that we explore, the case study examples that we go through, but also in terms of the heuristic that I'm asking you to take away today and to actually give you the answer to one of the key questions of today's program from the very get-go, and that is this. We're going to critique and have already a failure to provide holistic, strategic, integrated solutions when taking into account advances that may or may not have been made, either in cash or on the balance sheet. The principle that we're thinking you should very seriously consider as being the key to all of this is that it's actually very polarized, and it's almost as polarized as the law to the vibe in terms of those two dynamics. That principle is this. If there's not the discipline and desire by the underlying customer to not only invest to get this stuff done right at the moment of doing a holistic estate plan, but also to maintain an investment over time. So in other words, continue to invest in the estate plan, annual health check style, to make sure it's continually doing what it's expected to do and not a set and forget. Our actual sense, our experience is that it may in fact be better to not invest at all. So in other words, just say, well, I'm just going to ignore any balancing adjustments at all. It's just going to be what it is. everyone should be happy they're getting this windfall gain anyway. And I'm not going to get caught up. In our experience, the customer actually signs up or buys into this idea that it's better to be approximately right as opposed to precisely wrong. And if we go back to that very, very first case study, if you go back and say, well, this is the factual matrix that we've got before us, I mean, maybe, just maybe, and I'm making some assumptions about how well the blended family may or may not get on, but maybe, just maybe, one of the simple workarounds, one of the simple solutions, one of the simple approaches would be to say, well, I'm going to give the control to the 3 kids and their stepfather equally, and I'm going to give my personal assets 50% to each of those 2 branches as well. And then I don't care about loan accounts. And frankly, if they can't work out how to deal with the family trust and reach an agreement at the relevant point in time, it's their problem, not mine. Fully get that that is way oversimplifying what can often be the case, but also give the very big disclaimer that the minute you say, no, well, actually, we do want to make some adjustment, the minute you do that, we start to unravel very quickly. And the biggest, I think, example that we can give in this regard is what happens from a tax perspective. Now, when I use the word tax, we've had a few disclaimers already today, haven't we? I reckon there's another asterisk there as well. I'd actually say, when I say tax, I'm just talking about any revenue at all. And what are some other examples? Well, the obvious one would be stamp duty. You'd also need to be factoring in land tax. There's a whole range of additional government charges, if you like, that directly impact on what we're trying to do here. And, you know, it's like the whole heuristic that is a go-to one for a lot of us in the holistic estate planning space, and that is this idea that, you know, or the quote, there's only 2 certainties in life, being death and taxes. The footnote to that quote, I think, in the modern era is, well, at least with death, you know that's it. Whereas what we're seeing in the taxation space, particularly at federal level, but increasingly at our state government level as well, is that just dying is not going to be enough to get you out of the clutches of our revenue authorities. And when we then overlay that into some of the, particularly the will drafting rules, but holistic estate planning as a whole, it very quickly starts to unravel. And I particularly call out the approach that the tax office has in relation to trust generally. Super being just one form of trust. We're talking to you, if you're watching this program live, in June 2024. We've got a situation where the rules in relation to superannuation generally, but particularly in relation to SMSFs, have been radically re-engineered because of a 2-pronged approach in the last 6 months. The first one, previous strategies to help manage what I sort of refer to as fast death tax. So this idea that if you're making a death benefit and there are no tax dependents, that can be fully taxable. Whereas if you'd actually withdrawn the funds the day before you die, you can actually get them out completely tax-free, assuming you've met some other condition of release. So that's number one. The tax office has changed its tune in terms of how it will treat those arrangements. Number two, very high profile one, being this idea that there's going to be a $3 million, $3 million problem. There's going to be a problem of many dollars if you are lucky enough to have over $3 million inside your member account at any particular point in time with those new rules that have come in. So hence, one of the most popular posts I think we've ever done, that very simple cheat sheet in relation to what our friends there, picture telling 1,000 words, what our number crunchers in Canberra at Treasury and the tax office are trying to do to all of us, including in an estate planning context. With that background, with those summary points, with the threads of some case studies already, let's drill down into one of the other key line items today. So we spoke about, at a headline level, one of the biggest key line items, which is, well, what is the answer here? And the answer, I think, to repeat, is polarized. The answer to today's program is either ignore this in total And if you're going to adopt that approach, make sure you're off risk, make sure the customer understands what approach is being adopted and the reasons why. Or you go to the nth degree. And not only do you have a huge sign-off and investment process that every relevant advisor, whether it be the accountant, lawyer, financial planner, or all three, are fully engaged in. And not only do we do that at the time of implementing the holistic estate plan, but we undertake to keep reviewing that on at least an annual basis. They're your two polar opposites. If we're going to go down the invest in the process side of things, well, one of the first things we're going to do is we're going to consider what actually came out in one of the, sorry, let me give you a position here. Is that we've got, I don't know how many team members internally that habitually refer to the will equalisation provision as a hodgepodge provision. The initial invite from TEN did exactly the same. And frankly, it probably sounds a lot better than hodgepodge. But be that as may, the technical legal term is in fact hodgepodge. If you Google hodgepodge, you'll probably still get quite a lot of answers, but it's not technically what we're talking about. Or let's avoid that debate on the English language entirely, and let's just refer to some sort of equalisation or balancing clause. It actually goes back a fair way. So another picture telling 1,000 words. Rolling Stones are out on tour again in the US. If you haven't seen that meme before, read it carefully. It's probably true, hopefully true. Long live Keith Richards. What are we talking about in a practical sense? Well, we're saying that there are a whole range of things that might impact on how we draft a hodgepodge clause, how we draft a balancing adjustment clause, how we draft an equalisation clause before we even get to the will. And then on top of that, there's a whole range of issues that might mean that whatever we try to do under the will then be changed by intervening events, right back to our very first case study where we did an asset revaluation reserve. Now, I've listed out, I was going to say half a dozen, say 5 of the key things that we're seeing where even though an attempt has been made under the will to do a hodgepodge provision, an equalisation provision, a balancing provision, there's been some other intervening factor that has completely undermined the drafting in the will, but the will was never revisited. So what are we talking about? Well, we're talking about if some sort of capital gains tax event happens in relation to any asset, either in the personal estate or more widely. Classic examples, particularly in an estate and succession planning where there's a business involved, is that something is done to do an internal reorganisation. You haven't actually sold to any third party, but you've relied on one of the limited rollovers available in the small business space, particularly 328G or Division 125. So that's gone off and triggered a whole lot of different transactions. It's quite possibly radically changed who the owners of a particular business are. We've lost count of the number of situations where people haven't then gone back and thought, well, how does this impact on the balancing adjustment that we did under the will? I'd certainly call out that if there is an entity involved, that potentially creates more flexibility. But again, go back to that very first case study, go back to the Clark and Inglis and ask ourselves, well, did having the trust involved help us there? Or did it actually make it doubly worse? It can be such a thing. And actually 100% change the outcome, or by having that entity involved. The other 2 points to say is that, towards the bottom there, is that loan accounts can be used for good and evil. So, you know, we've seen countless examples of that, particularly over the last 2 or 3 years with the gift and loan back cases, and we'll jump to that straight now. The gift and loan back arrangements in the context of trying to protect assets under the estate plan are traditionally used where there is a blended family and where you've got an asset, for example, the family home that's owned in somebody's name, but we're wanting to shift the value of that to the right entity on the page. Now, I'd actually say the gift and loan back arrangements are just one specific form of a hodgepodge provision. So in other words, it's looking to adjust the values on the balance sheet of the individual to achieve a particular outcome that aligns with their personal or commercial objectives. Now, with the high-profile gift and loan backer cases, they've actually been doing it to make sure that 100% of that value sits inside a controlled entity, for example, discretionary trust. So in other words, it actually takes it out of the clutches of the estate and therefore out of the potential attack under the family provision regime. For those of you who are dialing in from NSW, New South Wales, or have any clients or customers that are in New South Wales, you'll know that their notional estate regime, another thing that has occupied quite rightly many PE and events, particularly sensitive in the context of doing any of these arrangements because they can actually be unwound. For the purposes of the day, let's just ignore the New South Wales regime. With the gift and loan back, what are we doing? Well, step one, we're basically gifting cash, or a promissory note can be used potentially in replacement of cash, and hence my inverted commas of the word cash in step one, to a protected environment. So getting it into the right vehicle. We then, at step two, go back the other way and lend the promissory note, lend the cash, lend the underlying synthetic equity, if you like, in the property back to whence it came, while taking security over the asset that we're trying to protect or we're trying to shift the value of. Now, all of that can be done without tax, all of that can be done without stamp duty, all of that can be done in a way that moves as much as we like off the balance sheet of the individual and therefore off the balance sheet of the person's will, and instead moves it into a protected environment. The point being, for the purposes today, that I'd like you to think about gift and loan back arrangements as just one iteration of the equalisation hodgepodge balancing adjustment regime. Quite often in the context of where we're trying to protect the entirety of the estate, it's been used for evil. I would say in combination with asset revaluation reserves, it can actually be used for good purposes. But again, call out Clark and Inglis, call out the Fisher decision, call out the Liu case. For those of you that haven't looked at that recently, Solomon Liu, quite a famous Australian retailer, owned a big chunk of Myer at one point in time. Showing my age a little bit because we're calling out a regime that was on the table back in the late 1990s, early 2000s, that proposed to tax trusts as companies. Now, that was eventually taken off the table. The legislation was released, however, and it saw a strategy that was promoted quite heavily, particularly in Victoria, that basically saw if you had a trust, you would, step one, do an asset revaluation reserve. So very similar to our Clark and Inglis style case. This is your family trust. Step two would be that you distribute that out to the beneficiaries of the trust or selected beneficiaries of the trust. So distribution out. And in the Liu decision, you cannot make these cases up. He arranged for a chunk of money. When I say chunk of money, I think it was like $160 million, as you do, to his son and his daughter. Now, as it happened, his son and his daughter were both married. And for those, actually, I'm going to be very careful with this because there are people online from Tasmania, but they weren't married together. So it's like that perennial question, if you get divorced as a Tasmanian, are you still cousins? With the disclaimer that I was actually born in Tasmania, that's the only reason I get away with that. No, that is not the case here in the Liu decision. Here, the son was married to a lady, unrelated lady. The daughter was married to a bloke. Now, did these two get together? I don't know, but what I do know is their relationships busted up at exactly the same time. Now, why is that all relevant? Well, that's all relevant because step three, which I didn't tell you about, is that in relation to the 160 million, a decision has to be made as to how that sits on the balance sheet of initial family trust. Now, again, disclaimer, not an accountant. However, basic accounting will tell you that there's really only two ways you can do that. You can either have that amount stay outstanding as a loan, or B, gifted back into the trust. Now, cannot make this stuff up. In this particular case study, once the marriages broke down, these two were asking, look, it's still a loan, and prove that it isn't. Whereas Solomon Lew, on behalf of his son and his daughter that were going through the matrimonial bust-up, said, no, it's been gifted back into the trust. Here's a balance sheet to prove it up. And the son-in-law and the daughter-in-law said, well, hang on a second, show us the deeds of gift that we signed agreeing to gift that back into the trust. Now, other than an intervening alleged assault in a car park at the Crown Casino, we don't actually know what the end outcome was of all of those discussions. So the family law case is actually settled. The music stopped. The case study examples stopped, not resolving whether the deeds of gift had ever been signed. Now, why and how is that relevant for us when we talk about the gift and loan back arrangements, when we bring it back to any of the hodgepodge provisions? This demarcation and the pre-death transfers, ignoring tax attributes for a moment, we'll get to that, and ignoring the notional estate rules, because we've touched on that already, so key. So key that we understand the distinction and that we ideally document exactly what is going on. Let me give you one last case study example from literally last week. Again, picture telling 1,000 words, it possibly falls under stating the bleeding obvious, but maybe it doesn't, and maybe you need to get out a little bit more as well. Reading a balance sheet, $2 million amount set out under the liabilities section of a company balance sheet. So it was set out under the liability section of company balance sheet. So in other words, the company owed this particular individual $2 million. Now, this particular individual, cannot make this stuff up, was getting sued. We had to go through their balance sheet. They didn't have the family home in their name. They didn't have any other assets in their name. We thought they were totally fine until we find out about this $2 million amount. Everyone runs around crazily for about 3 days. Then print it out. We've got a heuristic internally, we always try to print stuff. Print it out, have a look at it more closely. Even though it's in the liability section, even though it appears to be an asset of the at-risk director who's getting sued, can you see that on the screen? I'm hoping you almost can't see it on the screen. Everyone else missed it. There was a little negative sign before the 2 million. So what's a negative on the balance sheet? It's on the liabilities, but it's a negative. Well, it's actually a positive. He didn't have a $2 million debt owed to him by the company. He was owing the company $2 million. Now, happy days. It suddenly took the asset protection issue right off the table. But for the purposes of the day, again, we've got it. It's not just $2 million. It's a $4 million swing on one little negative sign sitting in the balance sheet. Now, if you're like me, you're saying to the accountant, like, seriously? Why are we doing negatives? Wouldn't you just move it up into the asset section? Is it today's day and age with all the computer stuff, is that too much to ask for? The footnote, of course, is that, yes, he's out of the asset protection, but it had been missed by everyone on the way through. And when a company lends money out to an individual, you've then suddenly got a big Division 7A problem from a tax perspective. We're actually sort of quite happy about that, as it turns out, but practically a huge issue when we start going through a number of the case studies that are going to close out the back half of today's program. Now, any questions or comments, feed them through. We're checking that as we go, Lisa said. We'll give a couple of minutes towards the end if you haven't had any questions come through before then, but please make sure you do think about feeding them in plenty of time so you don't miss out. And I'll particularly call that out because if you've dialed in to today's session and you were expecting to have particular issues dealt with and they're not yet dealt with, we're now in a zone where you might miss out on those. So now is the time. Do not leave it till filling in your evaluation form after the event. Get the question in now. Make sure you get what you need out of this program if it hasn't otherwise already been addressed. Before we drill down on those other case studies, let's just call out a handful of some of the key issues that we think you need to be keeping on your to-do list. We've got to think about the timing of all this, particularly where the spouse is involved, even more particularly if there's blended families. We've got one spouse materially younger than the other, as an example, one spouse in very poor health compared to the other, regardless of their ages. You're automatically making the approaches that need to be considered that much more complicated. You've also got to think about at what point in time, even if you don't have issues about people checking out at radically different points in time, you've still got to think about at what date you're looking to strike the balance at. And as a really simple example, and I've noticed this, again, showing my age a little bit, I've noticed this sort of fade in and out of popularity. So there's a period in a lot of our careers up until about 2 years ago where the idea of adjusting for inflation was like, seriously? Like inflation's running at what, 0.00 what percent? I don't care. Whereas there's other points in time, and maybe we're heading back to those now, where inflation's in double digits, 8%, 9%, 12%, 14%. Suddenly, the point in time and how you adjust for the benefits that have been provided over that period of time can become radically important, even if it is air quotes only in relation to CPI. We've spoken at length about related entities, cannot understate that in today's day and age. And I even put superannuation into that category. We've all got superannuation. All our customers have got superannuation. If we're worrying about fast death tax, we're worrying about the $3 million cap, we're worrying about whether it's actually going to be received tax-free or whether there's going to be a 16% tax, 16.5% tax, or a 31.5% tax. They are material and radical differences, particularly in the context of, you picture telling 1,000 words, trouble brewing, particularly in the context that for a lot of people these days, if super isn't their biggest asset, it will definitely be their second biggest asset. So it goes to the heart of almost every estate plan that we're going to look at. And, a lot of people will treat super and say, oh, we don't really have any entities involved. Well, you sort of do. Super is just one other form of trust. So you sort of do. And so you sort of do need to keep coming back to what I'm saying is one of the key heuristics out of today, key lessons, key rules. And that is either you're going to ignore all of this or you're going to deal with it completely holistically and regularly and keep it updated. And anything in between, we will say, is highly dangerous, highly risky, even if you have tried as a firm, as an organisation, to get off risk on it. Let's hit some of the headline cases that go to the heart of particularly will equalisation clauses, so hodgepodge provisions. Tenant is going back to the 1900s, so years ago. It is in your paper. I'm not proposing to go through it in a heap of detail other than to call out that it does talk about the two key principles, and they're almost like parallel principles, but the point being that we do end up with effectively the same outcome whichever way we go. And the idea or the focus in terms of these early hodgepodge decisions is that we're trying to get to an outcome that is equal, regardless of whether that is fair. So it's a very interesting way to think about some of these things. And if we particularly consider I'll just take you there, the further principles, where am I looking at? This one here. So we have asked the question a couple of times today, well, at what point in time are we actually looking to achieve the balancing? At what point in time are we looking to achieve the equalisation? At what point in time does the hodgepodge clause get applied? And Tennant gives us some guidance on that and says that, well, the default position is that we look to the date of the advance. That's the starting point. That's where we're going to make the adjustment as and from. Now, in a very simple state, that probably is the keeping it simple approach. It keeps calling out this question that we've asked already many times today, and that is, well, how do we actually define achieving an equal result? How do we actually define achieving fairness and parity between different potential ultimate beneficiaries? And let's talk about that in the context of some of the examples we've gone through today. So financials are a classic one. We've spoken about the impact of AARs. We've spoken about my example out of the cupboard in the last week of negative. It's like the financials are absolutely the starting point, but you've heard me say this before, no doubt. Like, how do you tell the difference between a good accountant and a bad accountant? The bad accountants are people like me. So when you say, well, accountant, sir, madam, what's 2 + 2? A bad accountant like me says 4. Don't even have to think. The good accountants, when they're asked what's 2.2, they lean in, they hush their voice, they probably draw the blinds a little bit as well, and they say, what do you want the answer to be? In that context, with what we're talking about today, be aware, work collaboratively, and understand that the financials can potentially say whatever the accountants are wanting to say, and that can have a material impact on no matter how good you think your drafting is under the estate planning documentation. Be aware of some of the overlays that come in. We've seen the tax office, particularly in relation to Section 100A over the last while. There's a Guardian decision that's gone through the court system. Separate agreements that are put in place, Division 7A would be another example, we've touched on that as well, where we've put in place particular agreements to achieve an outcome, or not even to achieve an outcome, to comply with the rules under a taxation regime. There are second-order consequences of what happens under those provisions. And those second-order consequences are constantly changing. If I give you one more example in relation to Division, say, 7A as a specific example, up until, call it March 2024, there seemed to be a way to say, well, if you've got a debt outstanding as an individual back to a company, so back to this example here, negative, positive. So in other words, the guy owed the company that amount of money, Division 7A applied. If he died and the executors of the will, before probate was issued, decided to forgive that amount, there was an argument that the tax office accepted that said there were no Division 7A consequences to that forgiveness. Now, in around March 2024, the tax office has gone and withdrawn their position on that and said, no. If you forgive that debt under the estate plan, you will have to take into account Division 7A. What are you doing? What's your firm doing? What are your customers wanting you to do in relation to the existing agreements and deeds that are in place to contemplate and regulate the balancing of all intergroup loans? What are we doing to prove up the existence of debts with children as a classic example? So if you've got agreements and deeds in place, are they actually binding, or are they like a typical inter-family relationship? Are they like the oral agreements that aren't worth the paper they're written on? What is it that actually documents the terms of those arrangements? Do we need to be going back to bank records? I can speak of my own family itself, not big dollars involved. My parents have been lending money to a particular sibling. I'm trying not to sound tortured by this. It isn't me, but I'm getting help and guidance. Maybe I'm just jealous. They're saying, oh, look, don't worry about it. You can just check our bank accounts to see exactly how much money this particular sibling has borrowed over time. Now, quite aside from me being a lawyer and saying, well, are they loans or are they simply gifts? There's no evidence around that. One of the key evidence givers being my mum will be dead when any of this ever comes to pass and it gets debated. Yeah, absolutely, we can go and look at the bank records, but that doesn't help if the sibling then argues, well, no, that was actually a gift, not a loan anyway. Running ledgers is another potential solution on documenting these arrangements. I actually personally think it runs the risk of being just as traumatic as anything else that we talk about, written statements or otherwise. Ideally, we keep going back to it. If we're going to have adjustments, the lawyers have to be involved, the accountants have to be involved, it has to be regularly updated. And any of the ideas on this page in isolation run the risk of the old Dunning-Kruger. So a little bit of knowledge, a little bit of insight actually runs the risk of causing us more damage than it's worth, and actually runs the risk of people ending up with these kind of blindingly obvious but particularly unhelpful statements. Let's use the Pritchard decision as a specific example of what we've been talking about here. Again, it's in your material. It does tick off a few more things over and above the original tenant decision under the intestacy regime. So that's this idea that if you die with no will, that the government actually sets out what is going to happen. There are balancing adjustments that are mandated at law under that legislation. What Pritchard tells us is, well, yeah, that's helpful, but that's it. It's not, you can't place any of those rules any higher than helpful. You really do need to apply the principle you spoke about near the start. We need to be applying the vibe. We need to look at the will. We need to look at the overall concept. We need to look at the context and the vibe. We need to actually think about how much dollars are actually involved here as well. And then we need to factor in whatever documentation has been produced. Now, get a load of this. You notice that I haven't read that out for you. It's one sentence. I don't think there's any punctuation. It might have only been an extract of the entire sentence. It makes you a little bit tired if you're like me trying to read the thing. It's the clause out of Pritchard. And the really interesting thing is actually Pritchard, if you don't look at any other cases today and you're even remotely interested in this area, I'd actually say Pritchard is probably one of the ones you want to look at. Their honours, the court, held that there are actually 6 different interpretations, which I've set out in material for you, as to what those provisions actually required. And one of the comments that I'd make is that it's sort of like you're consistently inconsistent, if that's such a phrase, in terms of how the willmaker and his advisors has dealt with this over time. The court noted very loudly and clear, it's not for them to be trying to rewrite the clauses. It's not for the court to try to apply the vibe. Like they've got to do the best they can to create certainty in a situation where, you know, ultimately it may have been that a number of the advisors were basically had a paper bag over their head when they're dealing with some of this stuff. And ultimately, they had to try to pick the formula that gave the most equitable outcome based on everything else that they were able to consider in the context of that case. So some of the checklist items that I've put under there is that, you know, based on even those cases, we need to understand what the actual formula is. Even if there's 2 methodologies about how you get there, we've still got to actually have a situation where there's one outcome, and that outcome needs to be expressed in actual dollar terms. So we can't have a situation where we're saying, well, we're going to make an in-specie distribution of a particular asset to try to get adjustment here. Even if there are assets that are underlying that will be distributed, we still need to determine what the dollar value is of those assets and do the calculation as at the date of the transfer in terms of that valuation to get the adjustment to occur. Now, the interesting thing, and which I think is still unclear on the cases and probably a lesson that we're all going to learn as this area continues to evolve, is that in order to make that adjustment, you've potentially also got to physically wait until there's an actual realisation of the underlying assets themselves, because that's the only thing as executors that's going to give you that absolute certainty. If the estates will say, no, actually, we do need to wind things up here, then the only absolute certainty with proceeding is that you're potentially trending back into the rule of thumb that I touched on earlier, and that is, well, are we trying to be approximately right here as opposed to precisely wrong? And the nervousness, and we're seeing this all the time, I've lost count of how many examples we've seen of this in just the calendar year of 2024 is that some of the equalisation provisions that are being put into people's wills are, frankly, I was going to say incompetent. That's not quite the right word, but the drafting has material opportunity for improvement. We've had a few pictures telling 1,000 words. Here's a video that might tell a few more.
I believe you have a filter turned on in the video settings. You might want to take a look.
Can you hear me, Judge?
I can hear you. I think it's a filter.
It is, and I don't know how to remove it. I've got my assistant here. She's trying to, but I'm prepared to go forward with it. I'm here live. I'm not a cat.
I can see that.
Quote of the year, I'm not a cat. Quote of the decade, I'd say I'm not a cat. Why am I including that? Well, you're either team cat, and that's effectively the only cat meme I can live with, or you're not. What are we leading up to here? Well, we're leading up to what I think is arguably the thing that is absolutely so hot right now. We've actually sort of been glossing around it for the entirety of today's program. And that is, if we're going to do equalisation provisions, what are we doing in relation to tax? Now, I'll give the disclaimer here that even from the off, when we start talking about tax equalisation, we are looking down, I would argue, a seriously dark corridor. So we've gone through all of the sort of general hodgepodge issues about saying, well, how do we do with entities? How do we do with loan accounts? How do we do with the balance sheet? How do we do with even record keeping? Like, how do we know what the actual dollar amounts are just in terms of the here and now? At least with all of that discussion, we're actually looking back. We're looking at the historical position in relation to those arrangements. When we then start overlaying the tax, not only have we got all of those complications, we've then got future situation in terms of potential disposal or potential assets. But on top of that, we've got all of the potential risks about what might happen to the taxation regime at any point between the drafting of the holistic estate plan, the death, and the final attempt to achieve some form of equalisation. And what I want to call out, and we do this, but we don't do it very, very often. What I do want to call out again is that this polarisation, and I'm not encouraging any of us to just flippantly say, oh, we're not going to work in that area, or we're not going to do that. You know, you want to do that, you've got to go see some other firm. That's not what I'm suggesting. What I am saying is that by the time you stack up all of the issues that we've been speaking about today, and we haven't even got to tax until now, the last 10 or 15 minutes, when you then overlay what are the tax consequences of these equalisation provisions, there is a potential, I think, for a lot of customers and a lot of advisors to look and say, well, look, it's like an SMSF will or a super will. Hodgepodge provision seems to get an inordinate amount of attention, like super wills, but it's got two other similarities to a superannuation will as well. The first one is it's an undefined term. No one really knows what the term means. I say that with all respect to advisors that work in this space. We're the same. We've got about 8 different versions of a SMSF will. That's point one. The second one is what I've put it on your screen there. I'll use a highlighter pen as well, is that there is arguably an inverse proportionality between the amount of time that we spend talking about SMSF wills, talking about equalisation and hodgepodge provisions, with the actual value, the actual utility that's delivered at the end of the day. And Todd mentioned in your materials is a classic example of that. So that is an attempt to achieve a hodgepodge outcome. It's an attempt to achieve equalisation. It's an attempt to take into account specific matters from a tax perspective, particularly capital gains tax. But it almost failed from the get-go because there were particular assets that might be sold very soon. There were some assets that may not be sold at any stage, but even if they did, there was then a question of whether there would be CGT or wouldn't be CGT. Let me give you a specific example of that. A family home that was a family home of the will maker will be capital gains tax free if it's sold within 2 years of the date of death, full stop. If that family home, though, has gone to a beneficiary who then chooses to live in that family home, well, it could potentially be tax-free forever. So when are you going to have your equalisation? How is your equalisation going to be calculated? And what are you comparing against? Because by definition, you can only have one family home. So you're not going to have apples for apples, whether you're talking about superannuation, an investment property, a share portfolio. You then start to overlay, and I haven't even got it on the slide here, it didn't come up in the Todd case, but I can tell you it's coming up so much. And that is, you've then got to consider CGT event K3. So that's the one that says if you've got taxable Australian property that passes to a non-resident under a will, you'll automatically pay capital gains tax at that point in time as well. You know, suddenly your checklist under an equalisation provision that purports to deal with tax can go off the charts. So what are the top half a dozen or so questions that I'm saying you should be asking before you even remotely consider a tax equalisation clause? Well, the first one is, are you going to actually pick and choose which assets are going to be equalised? And if you are, you know, second and third order consequences or questions on each of these ones aren't there. Because if you are, you then need to say, well, how often I'm going to review that? Because if my portfolio changes or if they go and change the tax rules on us, you know, I hate trying to predict the future on any of this stuff. You know, it's like the old heuristic. It's really tricky to predict things, particularly if they're going to occur in the future. Who knows what the next idea is going to be out of our friends in Treasury in terms of the taxation of anything. And particularly if you look at the context of the idea under the $3 million cap where they're actually going to tax unrealised gains notionally every single year. Like, who's to say that they won't start doing that in relation to investment properties, or who's to say they won't start doing that in relation to people's family homes over a certain dollar amount? Suddenly, you know, how are we factoring that future legislative change, even if we pick and choose particular assets? Also, are we going to do the analysis in the context of the gifter or the recipient? So I touched on the moment a really high profile one that gets a lot of airtime, that CGT event K3. Like, should a particular beneficiary who's living offshore get an uplift or an additional amount under the estate to compensate the fact that they're paying tax, even though the only reason they're paying that tax is because they're a non-resident? Now, I'm not for a minute suggesting what's wrong or right there. What I am saying is these are material questions. These are questions that come up all the time. These are questions that the answer will change for, even if the factual matrix stays the same for the underlying customer. What are we doing to make sure we get to clarity on these things? At what point in time are we actually doing the analysis? You know, we've touched on this already. Are we doing it at the date the will is done? Are we doing it at the date of death? Are we doing it at some later date when it's actually, when the capital gains tax is actually crystallised? And if we are doing it at that later date, are we going to put some parameters around it if someone says, well, no, I'm not a seller? Are we putting some parameters around the fact that we might have GFC number 2, the market's tanked, and so therefore we can't actually sell the asset, so we can't actually crystallise that? And what are we doing when we then have to overlay what's happening with the various entities? So all of this stuff, and coming to the conclusion of today's program, you've got those questions, now is the time to be feeding those through. It's a little bit like stuff that, you know, really sensible and appropriate haircut at a particular point in time. And look, maybe in some parts of Australia, still a very sensible and appropriate haircut. But for others, they will look at that and they'll say, you know what? Mullets are so yesterday, so too are any type of equalisation provision under an estate plan. Let's close out with 1.5 more case study examples. So this is dealt with in your material. It's the decision in Craven. It actually picks up on a number of the similar themes that we had in relation to the Todd decision that we just went through. I just wanted to give you some additional heuristics to take out of that. A couple of, all of these we've sort of already dealt with. So, you know, if there's not going to be a sale, well, there won't be any capital gains tax. Capital gains tax on one view is an elective tax. Where does that leave us? Where does that leave us? And we touched on this right at the very start with some of the other taxes. So what are we doing about stamp duty? What are we doing about land tax? When do we draw the line in relation to any of these particular issues? And, you know, at what point in time do we factor in any of the questions on this page here? We need to, I would submit, based on all of the horror stories that we've walked through today, we need to be able to make very informed decisions. We need to make sure that we understand what the precedents are saying. We need to assume that the errors that we're going to make, we need to assume that they will need to be fixed at some point in time somehow. And we need to understand, well, how can we be wise after the event? How can we build in the protections that are required to actually achieve the ultimate objective, which is that we want to be broadly fair, regardless of how we define the idea of equal. And in closing, think about one particular point of reference that I think is very, very helpful in everything that was spoken today. And that is, well, what happens if it's a family law bust-up? And the really interesting thing and the point of reference, and I think possibly the clincher as to what is actually going to be the case practically for us in a lot of situations. So we go back to this general principle that we're either ignoring it fully or we're dealing with everything holistic, but there ain't going to be much in between. And why am I relatively confident that for most situations, that's going to be the outcome, and the outcome's going to probably push us towards to ignoring it and getting off risk? Well, the biggest reason I think is by analogy, what we see in the family law situation, and that is that in a family law situation, you know the exact point in time when you're going to do the equalisation. You know when you need what you need to take into account, and you can apply the principles at that point in time. Contrast that with the estate plan. We've got no idea when any of this is going to arise, and therefore that can often be the clincher as to why these things are ultimately in the too hard basket. Lisa, back at Central Control, we are right on time. The contact details are there if anyone's got any questions or comments that were not dealt with during the program. But otherwise, thank you everyone for being part of today's latest PEN event.